Mr. Whitehill.
Hello. Before the short adjournment, I indicated I was a little bit behind where I'd hoped to be. I've got about 2/3 where I'd hoped to get to by lunchtime. I've done a little bit of judicious pruning, which I hope will pick up the pace during the course of the afternoon. I'll give your Lordship an indication of whether or not I've managed to make up for lost ground at 4:30. Before the short adjournment, drawing the threads together, I'd shown the Court 4 provisions that we relied on in relation to the judge's analysis of the constitutional balance, the no partnership clause in the shareholders agreement, Article 15.1, Dr. Sachs' service agreement, and then the provisions in the shareholders agreement concerning the shareholding. And armed with that, I then wanted to go back, if I may, to the passage in the judgment that I've indicated a couple of times that I'd come back to in more detail than I've passed over so far. Tab 8 in the judgment, page 166. And you will remember that we so far passed over those numbered subparagraphs 1 through 6. I now wanted to get to grips with the detail of it because this is what the judge relied on for coming to the contrary conclusion of a retrenchment. Starting off looking at paragraphs 4 through to 6, continuing over the page, those are the points which the judge makes by reference to the articles, and I've already dealt with that by making the submission to you that the statutory right to remove shareholders is baked into the articles, so I don't need to add anything more in relation to that. Paragraphs 1 through 3 is where the judge founds instead on part 7 of the shareholders agreement, and it will be of assistance to open that up and keep it side by side as we go through. So that's in the second volume of the core file at tab 20 at bundle page 546. So looking back at the judgment, I'm focusing now on Roman 1 through 3. And I'll start off, if I may, by just concentrating on 1 and 2. And if I can invite you to read those provisions to yourself again, please.
Yes.
We're on paragraph 386, page 166 of the core volume. So the point the judge is making there, if you look over to the agreement, is by reference to the clauses you see there, 7.1, 7.2 and 7.3. And that is going to form the basis of the conclusion that he drives, that there has been a carefully crafted compromise. And I have 2 things to say about those subparagraphs 1 and 2. The first builds upon a point my lady made at one point during the course of this morning, which is that if you look at his subparagraph 2, where he talks about the change that occurs when Minden becomes an investor, it actually rather understates the significance of what happened then. And that's for a reason which I can demonstrate if you turn over in the shareholders agreement to page 547. I just ask you to note clause 7.13, the final sentence. If the number of votes for and against a proposal are equal, the chairman of the board or other director chairing the meeting shall not have a casting vote in addition to his own vote. So before Minden came into the picture, 6-member maximum board, 2 Vollin appointees, Vollin outvoted 4-2. After Minden comes on board, 6-member board, split 3-3, no casting vote in favour of the chairman, with the consequence that at that point the petitioners relinquished their board majority.
Relinquished their voting majority.
They relinquished their voting majority such that they could not drill through anything that the investors did not agree with, and of course vice versa as well. But the second point, and rather more fundamentally, is that we very respectfully suggest that to reason as the judge does here, that because Vollin originally had a right to 2 out of 6 board members, it was, as the judge held, a violation of the spirit of the bargain if Vollin and Minden subsequently acquired voting control at board level. And the easiest way to make that point good is to take you back to tab 18 in the second volume of the core bundle.
Sorry, to reason that that will be wrong, you say?
Yes.
Yes, right.
I'll say it again. Because Vollin originally had 2 out of 6 board members, the judge's reasoning was that it was a violation of the spirit of the bargain if Vollin and Minden subsequently acquired voting control at board level. And to make that good, if I ask you to turn back in the second volume of the core to tab 18, starting it off for good form at page 435, you have open a document I've referred to a couple of times that we haven't looked at. This is the original shareholders agreement back in 2010, and I've already made the point in submissions this morning by reference to the judge's findings that as at the date of execution of this agreement, Vollin had very roughly 30%. It was a minority shareholder with 30%. If you turn on to page 448, and look at clauses 6.1 through 6.3, you see precisely the same trio of provisions in the 2013 agreement the judge is relying on in the passage of his judgment that we're focusing on at the moment. Just reading them out. 6.1, subject to 6.3, the maximum number of directors shall be 6. 6.2, the investors shall have the right, but not the obligation, to appoint and maintain in office 2. 6.3, if the board resolves to increase the maximum number beyond 6, the investor shall have the right, but not the obligation, to appoint and maintain in office 1 additional investor director for every 2 additional non-investor directors appointed. And those 2 clauses, 6.2 and 6.3, we say quite plainly create a right and not a cap on the board representation of the investor, Vollin. The purpose of this provision was not to limit the number of board appointees shareholder majority voting power could command. Its purpose was plainly to ensure that Vollin could have board representation roughly equaling its then 30% shareholding, which it would not otherwise have been guaranteed, because at the date of this agreement, the critical aspect of the factual matrix is that it did not have 50% of votes at a general meeting.
It's my fault entirely. I'm struggling. Can you just give me the headline point that you're making here?
Forgive me.
You know, it's my fault.
No. So in the judge's judgment, perhaps it's easiest if we go back to that in volume 1 of the bundle, page 166, and we're concentrating, my lady, on 386, Roman 1 and Roman 2.
Yes.
And the point that the judge is making is that the 2013 agreement appears to embody a 1/3 to 2/3 split between the investors and the other directors.
Yes.
The point that I'm making by reference to the provisions of the 2013 agreement is that they simply replicate what was in force in 2010. And when you look at the language of the 2010 agreement, it talks about a right, not a cap. And you ask yourself the question, why is it there? And the reason is because at that point, Vollin, at that point the only investor, only had 30%. So if Vollin had proposed anybody as a director, absent that right which you see embedded in the 2010 agreement carried over in 2013, it wouldn't have been able to secure any board appointment at all by use of its own voting power.
So is your point that the purpose of these provisions
isn't anything to do with entrenching
Yep.
the petitioners.
If your lordship casts your mind back, sorry.
Yes, that it's actually to enfranchise what was a minority and has been carried forward.
Precisely. And if your lordship casts your mind back to the way the judge summarised Mr. Hollington's submissions, when I showed you that passage where he summarised the submission about a contractual quasi-partnership, he said it connoted two things. First of all, the entrenchment of Dr. Sachs and Mr. Faulkner, and secondly, that the investors would not acquire majority board control. And this is the judge's discussion of his reasoning towards accepting the second of those two propositions. And the simple point is that it, with respect, misconstrues what the function of those provisions was. In origin, it was to give Vollin the entitlement to representation that it would not otherwise have necessarily been able to command. And all that happens is that that is then carried forward into the 2013 agreement. But what on any view it is most emphatically not is a cap. So looking back at the judge's judgment now, paragraph 386, Roman 1 and 2, we say that the provisions in part 7 that the judge relied on to draw his conclusions about the constitutional settlement simply doesn't work. And if you're with me on that, what we're then left with is what the judge went on to say at Little
So
Roman.
the criticism of Roman numeral 1 is criticism of the phrase only in a manner designed to ensure it remained in the minority.
Yes. Yes, that's absolutely correct.
Yeah, sorry.
No, not at all. And then I'm moving on to look at Little Roman 3. Now, Little Roman 2, he deals with the point I've just addressed, which your ladyship raised at the beginning, during the course of the morning, which is about the shift that happened in 2014. And the point I've already made is that what the judge says there materially undersells the significance of that shift. And then you see what he goes on to say at Little Roman.
The shift, I know about the deed of adherence, but how was the shift, I haven't, as a matter of mechanics, how was that brought about?
So there was, I suspect it's in the deed of adherence.
Right,
we can chase the answer to that down. But there was a contractual right on the part of Newey to a board representative without disturbing the 6-member maximum. And that's why I made the point to your ladyship that it went from being a 4-2 split with no casting vote to a 3-3 split with no casting vote.
Understood, thank you.
Just thinking about that one moment. It was the case, was it, that subject to the right to appoint 2 directors or 3, Dr. Sachs and Mr. Faulkner could block any further appointments to the board?
They could block under the articles. Well, as we'll see in a moment, there are 2 means of appointment to the board, mirroring the means of removal. There could be an appointment by shareholders in general meeting, and there could be an appointment by the board themselves. And under the company's articles, Article 14.2 was the mechanism that enabled the board, the extant board directors, to supplement their number with other appointees. And my lord is quite correct in recording that if that power was exercised, there had to be consent from Dr. Sachs or Mr. Faulkner. We say if they were still on the board, park that point for the moment. But I stand to be corrected if I'm wrong. I don't recall that there is an analogous veto right on the part of Dr. Sachs and Mr. Faulkner in the event that the appointment is made in general meeting by shareholders.
Yeah.
So on 166, at 2, the judge refers to the shift in balance when Minden comes onto the board. And then in the last 2 lines he says, but at the same time, the constitutional balance at board level was still weighted in favour of Sachs and Faulkner. This is because under clause 7.8 and article 17.7, Both of them had to be present in order for any meeting to be quorate, and under clause 7.13, both of them had to be in the majority for a resolution to be passed. Their joint approval was needed in order for any new director to be appointed, Article 14.2. So that's the point I've just made.
Yeah, what you're saying is he should have, to be accurate, have said their joint approval was needed in order for any new director to be appointed by the board.
Yes, unless I'm misrecollecting it and there's a provision that Mr. Hollington's going to tell you about. But my recollection is that there is, we're going to have to look at Article 14.2 in another context. But that certainly does entail the conclusion that if the board wants to appoint someone else, Sachs or Faulkner have to agree. There's no counterpart provision if the appointment is made by the members of general meeting. So at 3, the judge is saying, well, even after Minden come on board and it's a split board, Sachs and Faulkner still have protections because of what you see at clause 7.8 and clause 7.13. Now, those two provisions you find back in the second bundle. Again, if you turn please back to tab 20 in the 2013 agreement on bundle page 547. And you have the two relevant provisions set out there, 7.8 and 7.13. I'll read them in a moment. Just to telegraph where I'm going, we're going to say that the judge was plainly right in saying that these two clauses conferred special rights on Dr. Sachs and Mr. Faulkner for so long as they were directors. But to reason from that they were immune from removal is, we respect, a non sequitur. And quite apart from the general points I've already made to the court in that regard, there are two specific textual points to draw your attention to in these provisions. Focusing first on clause 7.8, subject to clause 7.9, the quorum for the transaction of business at any board meeting shall be 3 directors and shall include, insofar as they each remain a director, the founder director, the CEO, and if one or more has been appointed, the investor director. So that provision on its face expressly contemplates the possibility of Dr. Sachs and Mr. Faulkner going. And that chimes with another provision that you see back over the page, bundle page 546, focusing now on clause 7.4. As at the date of this agreement, the directors are Jonathan Sachs, Mark Faulkner, Brian Bolger, Jeremy Fletcher, and Robert Lind. So if Sachs and Faulkner have special entrenchment rights, we suggest that it is passing odd simply to refer to them in clause 7.4 merely as the directors in place, quote, as at the date of this agreement, unquote. And all the more so to lump them in together with Mr. Bolger and Mr. Fletcher, the 2 Vollin appointees, who no one disputes were at any time liable to removal at a general meeting by shareholder resolution, subject to Vollin having the right to appoint replacements for them.
The judge dealt with your first point at 396, didn't he?
Yes.
Insofar as they each remain.
Yes. I mean, this is, in a sense, another variant of what I possibly slightly discourteously referred to as the Schrödinger's cat point. It's the idea that there's been an agreement created which at one and the same time renders it permissible for them to be removed, but at the same time wrongful. And we respectfully suggest that that's a fundamental conceptual error. As I indicated earlier, it's one thing if you say there is an agreement on which equity superimposes a gloss. It's a very different thing to say I have interpreted an agreement to produce 2 inconsistent results. That was what I was proposing to say in relation to the constitutional settlement, so far as it concerns Dr. Sachs's removal. So I'm now moving on to the third of the topics I wanted to deal with in relation to that, which is the mental state requisite to support a finding of breach of what I termed earlier on the autonomous duty of good faith. Before I do that, may I think fairly briefly make 2 points. First is to clarify what significance actually attaches to this question for the purposes of the decision path on this appeal. And to that end, it may be helpful to ask you, you can put away bundle 2 of the core for a moment, and within volume 1, turn back to tab 6. This is our list of findings of breach of duty which the judge made. If you're with me on the submissions I've made so far, even before we come on to the question of does good faith mean honesty or something different, finding 1 has gone. Because even on the face of the judge's own reason, if you accept that the duty of good faith connotes fidelity to the bargain, constitutional settlement as he called it, if the constitutional settlement did not give Dr. Sachs and Mr. Faulkner the entrenched positions which he thought it did, that's the end of that part. And the same obtains in relation to finding number 7, Mr. Faulkner's removal, the only relevant difference between the two being, as you'll recall, Mr. Faulkner declined to jump before he was pushed, so he was in fact voted out. I'm also going to go on to make the point during the course of this afternoon that if you're with us on that, all of these findings bar finding 2 go.
Our finding.
Bar finding 2, finding in relation to process and Dr. Sachs's removal. Because all of these findings are similarly predicated on the view which the judge formed about what he repeatedly called the constitutional settlement. So why does the question of state of mind for breach of the duty of good faith matter? It matters for 3 reasons. The first is that the case law on this topic is directly relevant to the analysis which I developed earlier this morning by reference to Mr. Justice Leggett's decision in Yan Sang, and about the twofold way in which we say the duty of good faith works. Secondly, because this question of the mental state required for breach may well be relevant to finding 2, the issue about Dr. Sachs's removal and the process that was followed. And thirdly, because Mr. Hollington has a submission that if one reads the judgment as a whole, in light of some of the things in particular that the judge said when I applied for permission to appeal at the consequentials hearing in July 2021, the trial judge did in fact make a finding that we acted in breach of the autonomous duty. And that being so, it remains important for that reason as well. So there were 2 preliminary points. That was the first one. The second one is this. In his skeleton argument, Mr. Hollington advances a submission that it is simply not open to me on this appeal to contend that the autonomous duty of good faith connotes honesty or something akin to it. And I can show you how he puts that if you turn back a couple of tabs to tab 4 in the same bundle, and now look at page 58, bundle page 58. We're in his skeleton argument, his consolidated skeleton argument. Starting at paragraph 4, 3rd line, the investor's argument about the scope of the good faith clause upon the basis of which the court granted them permission to appeal is contradicted by their opening submissions at trial. For the content of the obligation of good faith, the investor cited Berkeley Community and Pullen. And then at the end of that paragraph, 5 lines up from the bottom, thus at trial both sides were saying the same thing as to the content of an obligation of good faith. The judge nevertheless meticulously subjected the authorities to an examination. You might pause and wonder why if we were in agreement, but I'll come back to that in a moment. And then he goes on to say, see Notting Hill, but the disinclination to consider arguments on appeal, which had they been run timorously below, would have affected the course of the trial. So far as that submission is concerned, I need to start by explaining what happened on this point below. And for that purpose, I need to ask for the first time you to have a look at something in the supplementary bundle. If you take out volume 2 of the supplementary bundle,
Are these documents not in the quotes key documents in the supplementary bundle?
I think that's right. I'm afraid.
Right. Okay.
I think this is one of 2 documents I'm going to in the supplementary bundle.
That's all right. I'm just trying to limit myself to the key documents in the supplementary bundle rather than the non-key documents in the supplementary bundle.
I detected a slightly defensive tone in my voice when I said that I'm aware that the supplementary bundle is quite a lengthy thing.
All right.
But at tab 62, the court has my written opening submissions to trial, and if you turn on within that until we get to page 481, I can show you what I said in writing. Paragraph 95, middle of the page, clause 4.2, good faith.
Sorry, I wasn't keeping up. Which
I'm sorry.
which paragraph are you in?
Oh,
I've got you.
Bundle page 481,
Yes, I'm with you.
paragraph 95. And you can see the heading with a note at the start of 95, so this is specifically dealing with good faith. 95.1, I said the content of an express contractual duty of utmost good faith was discussed by Mr. Justice Morgan in Berkeley. On the facts of the case, he held that, and then I set out the quotation. Then I went on to say this is a useful starting point, subject to the obvious point that the content of the duty will vary from case to case. Point Mr. Justice Fancourt made last year in the context of another petition. Quote, the exact content of any implied obligation of fair dealing or act with integrity will be highly sensitive to the particular context of contract. Now, that's what I said in writing.
Actually, you do yourself down. It is actually a key document in the key document for the supplementary bundle.
I was
For the
pleased
for the
that
transcript.
I'm surprised to learn that.
The transcript is tab 31, page 95 to 96.
I'm very grateful. And my apologies for not having cited it to you in that.
Right.
So that's what I said in writing, but I wasn't able to develop the point about the content of the duty of good faith in oral opening at all for this reason. First day of trial was the 9th of November 2020. On the 3rd of November 2020, 4 working days before the first day of the trial, the petitioners issued an application to debar us from defending this claim at all. And the basis for that was the suggestion that we had committed an abusive process by originally making a counterclaim against Dr. Sachs, which we later discontinued. The judge dismissed that application, and for your note, that's file 3 in the supplemental bundle, tab 66, page 761. But what matters for present purposes is that as a result of that, I had to spend the whole of my opening oral submissions at trial dealing with that application rather than addressing the substantive issues in the case. I did, however, return to the question of the scope of the duty of good faith in both written closing submissions and in the 2 hours that were allotted to me for oral closing on the final day of the trial. And I'll show you both of those 2 things now, if I may, and my apologies, assuming these aren't in the key documents from the supplemental bundle, so I'll take them to you in the longer set. The first one is in volume 3 of the supplemental bundle. You can put volume 2 away. Tab 78 in volume 3. And page 904 within that, bundle page 904 within that. And you can see the heading by the second hole punch, contractual obligations of good faith. And in his skeleton argument, Mr. Hollington quotes from paragraph 289 where I said to a large extent the meaning of a contractual good faith clause is a factual question. Factual is a bit of a misnomer, but I think more specifically, a question on the circumstances of each case. And then I said what you see if you go on to read, and if I can ask you to read these to yourself, 290 and 291. So you see that the submission was made foursquare then, that it imposes a duty of subjective honesty at paragraph 290. And I cited Carroyne, which I'm going to take you to in a moment, and over the page at 905.
What did you mean by that, subjective honesty?
Yes, now, your ladyship puts your finger on a slightly difficult question, because that formulation of subjective honesty emerges from Lady Arden's speech in Carroyne.
I understand.
But as I've accepted, and I think must be right, the inquiry does not end with the question, did you appreciate you were behaving wrongly? The question must be, as my Lord Justice Newey put it to me this morning by reference to Genting, subjectively, what did you think, what did you know, what did you intend? And then the question becomes, objectively speaking, is that dishonesty? So these are written closing submissions prepared during the course of trial, and it may not be very elegantly expressed, but as you'll see in a moment, the language of subjective honesty is derived exactly from Lady Arden's speech. And then you see over the page the citation from Barnsley and Noble, which was a decision of Mr. Justice Newey when still sitting at first instance. So that's what we said in writing.
As a matter of fact, just while you're there, I see also paragraphs 315 and 355. I mean, there may be other bits too, but I did see 315 and 355.
Yes. Your Lordship absolutely has it. I'd omitted to recall that, but you see the submission set out clearly at 315. Not enough to show incompetence, impropriety has to be squarely put and proven.
And you come back to it really in 355.
Yep. Yes, 355 is dealing with Mr. Faulkner.
Yes, but in terms of whether the idea was run, that good faith meant this.
Yeah. So, during the course of the morning, my Lord Justice Snowden was asking me about how it was put at trial. And leaving Dr. Sachs aside for one moment, turning to Mr. Faulkner, it was put foursquare on the basis that, as the court will see in due course, in August 2016, Mr. Faulkner circularised the board resolution purported to be coming from his fellow directors, but without any prior authorisation from them. And I'll show you the judge's finding about that. But his finding was that we decided to expel him in 5 minutes with the word the witness used after that had happened. So our submission was, whatever you say the duty of good faith was, it was good faith to have expelled Mr. Faulkner.
Sorry, good faith?
Good faith to have expelled Mr. Faulkner for that simple reason. But I was going to show you my oral submissions as well, please, if I may, and that's in the next volume of the supplementary bundle, file 4. Tab 80. Bundle page 1129.
I have to ask you just to repeat it, sorry.
Supplemental bundle, volume 4, tab 80, page 1129. it's replicated in that pages to page format. And I'll start it off, if I may, on bundle page 1129, looking at the top right-hand quadrant. These are my closing submissions, picking it up at line 18. I said to the trial judge, since it remains part of the case that the directors acted in breach of their fiduciary duties, and also the investors breached their obligation of good faith in respect of the Cayenne transaction, I need to take you through two relevant authorities. The first of those is Mothue, so that is Bristol and West against Mothue, Lord Millet's celebrated discussion of the nature of the fiduciary obligation. And if you turn over the page to 1130, in the top left-hand quadrant, you can see what I took away from that, starting at line 22. What your lordship gets from that is to make good an allegation of breach of fiduciary duty on the part of a director, a claimant has to show something more than mere incompetence. And I'm not going to go through it in any level of detail, but if you just glance down at 1802 beneath it, one of the points that I in fact made in closing was that allegations of bad faith.
I'm sure there doesn't have to be intentional wrongdoing, by the way. If
No.
it depends what you mean by that, but
Yes.
obviously you can breach your fiduciary duties, Boardman and Phipps, innocently,
Sure.
properly, whatever, but you happen to be acting in conflict of interest, say.
Your lordship's quite right. It's an inaccurate formulation. But I took the judge through the relevant passages. Then I made the point at 1802 that an allegation of breach of duty hadn't in fact been made to our key director witnesses.
But at this stage, you're dealing with breach of fiduciary duty.
I am, yes. But then I go on 1802, so bottom left-hand quadrant. Second of the two cases I wanted to show your lordship builds on the analysis of Lord Millet and Mothue, a case called Barnsley and Noble. Long judgment of Mr. Justice Newey when he was still sitting at first instance. And then on that top right-hand quadrant, picking it up at line 17 perhaps, Mr. Justice Newey goes on to set out the extract from Bristol and West. I've shown you at 267, he says, I accept that. I read out an extended chunk. I said, those comments were made in the context of a will. They're equally applicable, I suggest to your lordship, where the duty of good faith arises in a contractual context. That has obvious relevance for your lordship in this case, to the extent the petitioners still seek to maintain the allegation pleaded in the petition that the sale of Newton Aycliffe was in breach of the majority investors' duty of good faith. So those were the submissions that I made to the judge. And just so you can see how that was reflected, how that submission was reflected in the judgment, we go back to volume 1 of the core bundle, back in the judgment at tab 8, and it was reflected in bundle page 151, paragraph 337, starting Mr. Gledhill disagreed fundamentally, and then picking it up 7 lines up from the bottom on the right-hand side of the page. This is summarising my submission that most of the investors were subject only to the duty under SHA clause 4.2 to act in good faith. But here the investors had acted in good faith because they'd acted honestly and in a manner which was commercially justified. Commercially, it was entirely right to have required Dr. Sachs to step down as a director in March 2016, given the state of the business at the time, which, as CEO, Dr. Sachs must have contributed to. So I think that goes some way to answering my Lord Justice Snowden's question this morning of how it's Bullrich. And the judge clearly appreciated that the submission on behalf of the investors in their case was a submission that to find a breach of clause 4.2 there had to be finding of irrelevant mental state. So much for the background. Turning to Mr. Hollington's submission, we have 4 points in answer to his suggestion that an argument about the relevant mental state is not fairly open to us on this appeal.
Could I just point out that Milofin hasn't dealt with one passage in his oral closing submissions that we refer to in our. That is at page supplemental bundle 4, tab 80, page 1118. Top left-hand quadrant, page 1753, beginning at line 10. For now, it is sufficient to note that, as my learned friend Mr. Hollington correctly points out, one of its key ingredients, in other words, of the duty of good faith, is the requirement of fidelity to the parties' bargain.
Yeah. Well, that is a different point.
Sorry, page 1118.
I'm
No, my
sorry,
fault.
Melody.
Tab 80.
Yeah, top left-hand. Yes, it's confusing. The transcript is page 1753,
Thank you. That's fine.
and then it's halfway down.
That is a separate point. I've indicated this is a different question. We're leaving aside the question of going back to Mr. Justice Leggett's discussion. I'm saying the two aspects of good faith, fidelity to the bargain and honesty. I do not dispute that it mandates fidelity to the bargain. I've made submissions in relation to that. We're moving on to a different point. We're on a different point. So, 4 points in answer to my learned friend's suggestion that we somehow, in written opening submissions, conceded sold the pass on the submission about the mental state. First is that it is not the case that a party has to set out its stall on all disputed points of law in written opening submissions at trial. Can do if it wants, but there are often good reasons in the interests of justice for not doing so. Most obviously to avoid the risk that witnesses may subsequently trim their evidence to hit what they understand to be the correct legal text. Second, I accept that if in opening you unequivocally state that the law is X, and the trial is then conducted on that basis and questions are not asked which otherwise might have them, if the law were in fact Y, that could give rise to unfairness. But I've shown you the full extent of what we were able to say in opening, and I respectfully submit that nobody reading our written opening could reasonably have understood it in that way. Thirdly, if a point about unfairness were going to be taken, we respectfully suggest that it is simply not open to the petitioners to run it for the first time on the hearing of this appeal. If there was a legitimate complaint here, it was an issue for the trial judge, and only for this court if the trial judge made a ruling which could have been shown to be wrong in principle on the usual restrictive grounds. And no point to this effect was in fact taken by the petitioners before Mr. Justice Johnson. I know my friend in fact began his oral closing submissions about 10 minutes after the extract I showed you from mine, and there was absolutely no suggestion that this point was not fairly open or that his clients had been prejudiced in any way by its not having been spelt out prior to closing submissions. Had a point to that effect been taken at first instance, it is of course a point which the first instance judge would have been in a perfect position to assess and decide fairly. It is a submission which this court, with respect for all the usual well-known reasons, would be in very considerable difficulty in determining. Fourth point, the court will have noticed, looking at the relevant passage in Mr. Hollington's skeleton, which I showed you, there was a claim that if this point had been developed in our opening submissions, the trial would have proceeded differently. But it doesn't give you any details of how, and that is a point which my learned friend will no doubt wish to address you on. For the time being, however, I will show you one document to lay down a marker, which is in volume 4 of the supplementary bundle. This time turning up, please, tab 79. So it's the first divider in volume 4. within that, please, if you could turn up page 962. That's the first substantive page of text. Paragraph 1. The foremost feature of the evidence is the absence of the Russian principals Abramov, Frolov and Abramovich. Second sentence. The motivations for Vollin Minden's decisions are critical, as are the discussions which Abramov, Frolov and Abramovich have between themselves. Among the petitioner's core allegations are breaches by Vollin Minden, the duty of good faith. So I suggest it is pretty clear from this that the petition is perfectly well appreciated throughout that allegation of breach of clause 4.2 might depend on proof of mental element. Their complaint in this document was not that the point was not fairly open to us. It was that they were disadvantaged because the three principals had not given evidence. I'll just ask you, if I may, while we're there, just to underline those opening words, the foremost feature of the evidence. I'll come back to that later on when we come on to consider the respondent's notice. So I suggest that is entirely inconsistent with the suggestion that the petitioners were lulled into any sense of false security by how we put matters in opening.
And without wanting to delay you many moments, do we find in this document allegations that your side did indeed act dishonestly?
It's a long document.
No, don't worry.
Not having recently reread it.
No.
But whilst we're there, perhaps I can just show your lordship one thing which may be relevant. If you turn on to bundle page 990. Straight answer to your lordship's question is I don't remember that having been so, but I'm sure Mr. Hollington will show you if I'm wrong. But what I can show you at page 990, there is a discussion of the relevant authorities. You see it beginning at 989, the contractual duty of good faith. And you see what it says at footnote 3, citing a decision of Mr. Justice Nicklin, which I think Mr. Hollington has included in the findings for this hearing. Mr. Justice Nicklin gave a largely agreed summary of principles applying to the construction of a contractual duty of good faith, going on to reject the submission that a breach of good faith required dishonesty. So that was the case.
I mean, I suppose in a sense, the question might be the other way round. Was it understood by Mr. Hollington that there was no need for him? I'm getting this muddled. We see three limbs in, say, Mr. Justice Morgan. One is, I think, honesty. One is adherence to the bargain. One is taking into account other people's interests. If it were alleged that there was a breach of all three, the mere fact that you said that two of those were irrelevant wouldn't matter, because the question of whether or not there had been a breach of the first of them would have been aired. Does that make any sense?
So I mean, if Mr. Justice Morgan's formulation, honesty we accept, fidelity to the bargain we accept, subject to the important query of what is the bargain. Where we part company is on the rather...
The taking into account of interest. But what I mean is that one wouldn't have expected the petitioners to be prejudiced if they were pursuing, as one of their limbs of argument, lack of honesty.
Yes. And that's why I showed your lordship the opening paragraph of this document. Absolutely clear appreciation that there was going to be an argument and there was an issue as to whether a finding of mental state was relevant to a finding of a breach of the duty of good faith. And that is precisely why they claimed to identify it to be a significant fact that none of the three principals in interest behind these investment vehicles have been caught. They said that that curtain had effectively been drawn over that critical issue by reason of their not having been caught. And that is consistent only in our respective submissions with an understanding of the fact that that was firmly in play in the proceedings below. So, having cleared those two preliminary points out of the way, I'm now turning to the substantive issue, which is the question of the mental state requisite to put oneself in breach of what I'm calling the autonomous duty. And the court will have seen the judge said this was a question of construction, and both parties agreed with that, but nevertheless said that it was relevant to look at authorities, because the shareholders' agreement was a professionally drafted document. The term good faith is something of a term of legal art. So if lawyers drafting a legal document incorporate a legal term, the default position is that they intend it in its accepted legal sense. And that is precisely how the judge himself addressed it. And if you go in the core bundle in the judgment now, tab 8, page 169, and if I can ask you now to read paragraph 400 to yourselves. So the trial judge expressly adopts the summary of the position to be found in a decision called Unwin by His Honour Judge Klein, sitting as a Deputy High Court Judge. And if you turn back to bundle page 159, the judge's discussion of Unwin runs between, if I can ask you to read to yourself, starting on 159, 365, through to 369.
I suspect we're all reasonably familiar with this passage.
If the court has seen that, then the critical takeaway point after you've finished reading 369 is what you see at 370, where the judge says on the facts, his statement of principle led the judge to conclude the defendant had acted in breach of his duty of good faith in terminating the contract, even though there had been no dishonesty or ulterior purpose in terminating the claimant's employment. So a finding of breach of the duty of good faith without any finding of either dishonesty or collateral purpose, with the foundation being the point that the defendant in Unwin had acted without adequate regard to the claimant's interests in his capacity as employee. But as the court appreciates, we say that the problem with following His Honour Judge Klein in this way was that Unwin was inconsistent with binding authority. In particular, we say Judge Klein purported to distinguish two decisions of this court as turning only on the scope of the particular clauses in issue. And Mr. Justice Johnson followed him on that point. And you see that if you turn back in the bundle to bundle page 154. Just comparing 154 to 155, you see that at 154, there's an italicized heading by the first hole punch, good faith clauses scope. And then over the page, it comes to good faith clauses content. And his discussion of Compass Group and Carroin is exclusively under the heading scope. And you can see he says at 350, in some cases, the issue is as to the scope or reach of a good faith provision. He then refers to Compass Group. He sets out a quotation, and then he says the issue was whether the good faith obligation was a general one or was more limited in scope. The Court of Appeal thought the latter. So Justice Johnson thinks Compass is only about scope. Then he says at 352, a similar result obtained in Carroin. And I'll come back to Carroin in detail in a moment, but over the page at 353, you can see how he deals with that authority. If I may respectfully say so, I agree with the explanation of Carr by his Honourable Judge Klein in Unwin, and it's really little too. Lady Justice Arden did not intend to set out what as a matter of principle a duty of good faith comprises. So our submission to this court is that Compass and Carr are not distinguishable as turning on the scope specifically of the clauses in issue. We say they have important things to say about the content of the duty of good faith. And we're going to say in particular that Carroyne is strongly consistent with the analysis of Yan Seng that I've already advanced to the court. Now, in my skeleton argument, I've relied on a run of 6 cases in all. But given time constraints, I'm going to prune that back fairly heavily. The first of those cases is a 1999 decision of this court in Medforth and Blake. Bundle reference is file 4 of the authorities bundle, tab 25, page 1297. And I ought perhaps just to show you the core passage in that I'm relying on. This is the leading case about the equitable obligation of good faith owed by a receiver. I think it was actually a Real Property Act receiver, but it doesn't matter. So it's not concerned with the contractual duty of good faith. But I rely upon it because, as I indicated in submissions earlier this morning, the duty of good faith is in origin equitable, and it would be surprising if the standard were different. And the key passage for this court's purposes, I'll merely invite you to mark it. It's the final page of the decision, bundle page 1314. It's the decision of Sir Richard Scott, with whom the other members of the court agree. And there's a passage starting just above on bundle page 1314, just above letter B, the right-hand side. You should have a sentence starting to, I do not think. And if I can invite you to mark that section, I do not think that the concept of good faith should be diluted by treating it as being capable of being breached by conduct that is not dishonest or otherwise tainted by bad faith. And the material passage finishes just before that last paragraph finally.
The judge wasn't taken to this, was he?
No, the judge was not taken to this. So that's Medforth and Blake. Then taking it equally quickly back in tab 23. Another decision which the judge was not taken to. The decision of the House of Lords in Manifest Shipping and Unipolaris. The question here was whether the appellant insurers were entitled to avoid an insurance policy on the basis of non-disclosures by the assured in the course of a liability trial. And the provision in issue you can see at bundle page 1255, letter B, sorry, letter C, which sets out the relevant provision from the Act, contract of marine insurance based on the utmost good faith. If the utmost good faith be not observed by either party, the contract may be avoided. And at trial, the submission, forgive me, on appeal to the House of Lords, the submission that was advanced, you can see if you turn back to 1222, just so you understand where you are, you're in the report summary of submissions on behalf of the insurers, and these were by Gordon Pollock, Queen's Counsel. And at G, you see this, nothing in section 17 supports the Court of Appeal's view that the only obligation when presenting a claim is to abstain from fraud. Duty of utmost good faith requires much more than simply the absence of bad faith. Although
But
where there
utmost
has...
good faith could be said to be different.
Yes, I understand that. I understand that. It is a, first of all, it's talking about utmost good faith. And secondly, it is in the context of a statutory provision. So I'm only dealing with it very quickly. And all I need to show you to cap the citation is 1264. You see the sidelining on paragraph 111 in the speech of Lord Scott. It's the whole paragraph, but actually you can neatly pick it up for the last 4 lines. Unless the assured has acted in bad faith, he cannot, in my opinion, be in breach of a duty of good faith, utmost or otherwise.
I see.
So, those 2 decisions out of the way, and now I want to take you, if I may, in volume 2 of the authorities bundle, to tab 10. And this is a case which will merit more detailed treatment. And this is the first of the 2 Court of Appeal decisions distinguished by Mr. Justice Johnson, which is Compass Group. Tab 10, bundle page 529. This case was concerned with a contract for the provision of hospital catering and cleaning services. And under the contract, the appellant health authority was entitled to make deductions from the amounts payable to the respondent contractor for performance failures. And a dispute arose between the parties because the authority took a pretty draconian approach to making those deductions. You sufficiently get the flavour of that if you look at bundle page 542. Look at paragraph 44 by the first whole punch. The monitoring reports which the trust prepared, totally different from the monitoring reports prepared by Medirest. The trust's monitoring reports included some assessments which were absurd. I set out 9 examples. 1. Chocolate mousse discovered on the 20th of August had become out of date on the 19th of August. It was removed that day. For this matter, the trust awarded a total of 56,360 services failure points. As a result of these deductions, a bit over a year into the life of this 7-year contract, the contractor terminated it, alleging that the authority's approach to deductions amounted to a repudiatory breach of an express obligation of good faith. And for that, if you can turn back in the bundle to bundle page 533,
I enjoyed fluff inside the notice board, by the way.
yes,
That's, yes. Sorry, paragraph.
bundle page 533. So we're looking just by the second hole punch on bundle page 533, and you can see the material good faith provision is set out there. It's clause 3.5. Trust and the contractor will cooperate with each other in good faith and will take all reasonable action as is necessary for the efficient transmission of information and instructions to enable the trust, or as the case may be, any beneficiary to derive the full benefit of the contract. Now, there was, I'm going to come to it in a moment, a question about scope. And the point about scope effectively was this, where you see, I'll just read the beginning out again, the trust and the contractor will operate with each other in good faith. The question was whether you read what came after that as separate from that, such that it was a freestanding obligation, or whether it was merely good faith to do the things which the clause went on to describe. That was the scope point. The trial judge found for the contractor, and the authority appealed to this court on 2 relevant grounds. The first was whether its conduct in making deductions was within the scope of the clause I've just read. And the second was, if it was, whether it had breached clause 3.5 in light of the factual findings which the trial judge had made. The leading judgment is given by Lord Justice Jackson. The other 2 justices agree with his decision to allow the appeal. Lord Justice Lewison, I don't need to take you to it, but paragraph 132, he adopts Lord Justice Jackson's reasoning, so that is part of the majority. And so far as that reasoning is concerned, we can pick it up on page 553, paragraph 106. at paragraph 106 and 107, Lord Justice Jackson deals with the scope question that I've just explained. And essentially he allows the appeal for that reason. And then he goes on also at 109 to deal with a separate question of the content of the obligation. 109, I turn next to the content of the duty to cooperate in good faith, limited as it is by the two stated purpose. You can see then that he cites manifest shipping, which I've just taken you to. 110, a decision called Street, which I'm not showing you. At 111, he then refers to Mr. Justice Voss's decision in CPC Group, upon which Mr. Justice Johnson relied. And then, for my purposes, the key bit is paragraphs 112, 113 and 114 continuing over the page. Could I invite you to read those to yourselves?
Sorry, 112 to...
112, 13 and 14
Yep.
continuing over the page. And of course, for my purposes, the key comment is what you see at the bottom of 554 in little Roman 1, equating good faith with honesty. So we say that in this case, in our case, Mr. Justice Johnson's treatment of Compass was wrong in that it discounted it on the basis that it was solely concerned with the product scope. And we say that it was also highly relevant because it does hold that the autonomous duty, good faith, requires a finding of dishonesty or something like it. And before leaving it...
For clarification, on your autonomous derivative thesis, for a derivative duty, is dishonesty also required?
No. No. So I'll come back to Yamseng in a moment by reference to Carr.
Is that odd? Is that odd?
Well, my lady, no, because what Lord Legate does in Yamseng is to say there is a duty of good faith. It means honesty.
Right.
But the existence of this duty may then also support the implication of other terms. And if your ladyship casts your mind back to Yamseng, on the facts of that case, it was about not selling undercutting products. So that was a hard-edged question of fact.
I see. Thank you.
Before we leave this decision, I'll just show you, if I may, another provision, another part of the decision in Lord Justice Beatson's concurring judgment. And I won't take up time reading the whole of 150 through to 154. But you see there that he references Lord Beatson's decision in Yamseng. And the takeaway point you can see in paragraph 154. It's really the third line onwards. In a situation where the contract makes specific provision, care must be taken not to construe a general and potentially open-ended obligation, such as an obligation to cooperate or act in good faith, as covering the same ground as other more specific provisions, lest it cut across these other specific provisions and any limitations in them. The reason I mention that is when we come on to considering the petitioner's complaints in relation to the 7-month window between March and October of 2016, when Mr. Faulkner was in place but Dr. Sachs was not, the judge makes findings in relation to the absence of board meetings and criticisms of that by reference to the duty of good faith. But a point I'm going to come on to is that the question of frequency of board meetings is in fact the subject of separate express provision. I'll come back to that. That takes me on to Carroyne, and that's in volume 6 of the authorities bundle. At tab 38. This is a 2013 decision of Lady Arden, Lord Justice Morbick, and Lord Justice Reimer. I'll start by making the point that you can see from the first page, bundle page 1836, the decision date was the 3rd of July. It's not clear from this series of reports when it was argued. But for your note, Yam Seng was decided on the 1st of February 2013. Yam Seng isn't, as far as we're aware, cited to the court in this case. Starting with the facts, the appellant here, Mr. McKillen, claimed that he had been unfairly prejudiced by breaches of a shareholders agreement which contained preemption provisions. Specifically, he said that one of the other shareholders, Mr. Quinlan, had for all practical purposes disposed of his shareholding to a third party, the Barclay brothers, but done it in a way that had been deliberately calculated to circumvent Mr. McKillen's preemption rights. And you can see what Mr. McKillen's arguments were on appeal. If you turn on to bundle page 1843 in the decision of Lady Justice Arden, in the middle of the page, paragraph 18, her ladyship summarises Mr. McKillen's arguments under 4 headings. Now, you see, point 3 is what she's calling the good faith argument. Mr. McKillen argues that there was a breach of an express obligation of good faith, and that's one of 4 buckets of issues live on the appeal. We don't need to get into the rest, but it is important to note that there were other issues too. 1 is the practical effect argument, 2 is the proprietary interest argument, and 4 is the security becoming enforceable argument. And for the good faith provisions themselves, you have to turn on to bundle page 1875. It's clause 8.5 on bundle page 1875, and it's the 2 subclauses 8.5.2 and 8.5.4. So starting with 8.5.2, each of the shareholders agrees that each of them shall at all times act in good faith towards the others and shall use all reasonable endeavours to ensure the observance of the terms of this agreement. So pausing there, that's in similar terms to clause 4.2 in play in this case. And then you see this at clause 8.5.4, which has no direct counterpart. Each of them will do all things necessary or desirable to give effect to the spirit and intention of this agreement. That has no express counterpart in the agreement before the court today. So that sets the scene for what the court had to decide. And the key part for your purposes is at bundle page 1847. Now, there's an extended section in Lady Justice Arden's decision running all the way down from paragraph 41 down to paragraph 56. And I don't have time to take you through all of that, but I can summarise it, I think, sufficiently in this way. I've just shown you that there are 2 different good faith provisions in play. There's a clause 8.5.2 obliging the parties to act in good faith. And separately, there's then clause 8.5.4, obliging them to uphold the spirit of the bargain. Now, so far as that first provision is concerned on appeal, the dispute centres on whether Mr. McKillen could establish breach absent any finding of dishonesty by the trial judge, who is Mr. Justice David Richards. And there are 3 passages that you need to look at for that. Starting on 1847, counsel for Mr. McKillen on appeal was Lord Goldsmith, Queen's Counsel, and you see his argument set out at paragraph 41. Lord Goldsmith submits But if the practical result of what has happened is to do the very thing the shareholders' agreement was intended to prevent, the good faith clause of the shareholders' agreement comes into play. The intention of the shareholders' agreement was that the shares would be offered by way of preemption. A party is precluded from cynical resort to the black letter of the agreement. The good clause must have some meaning. In practice, the whole of the interest of Quinlan's shares is being controlled in perpetuity by the Berkeley interests. So that's Lord Goldsmith's submission. Then you can see the submission for the respondents if you look down at paragraph 48. And this is summarising submissions made by Mr. Kenneth MacLean, Queen's Counsel, on behalf of the respondents. And for the moment, just focus on the last sentence of paragraph 48. The respondents proceed on the basis that good faith in the context of 852 imposes a duty simply to act honestly. Open bracket, they did not need to refine the meaning of honesty other than to say it was a subjective test. So that's the submission. And then Lady Justice Arden's conclusion is in the next paragraph. I consider the respondents a right to submit the requirement to act in good faith in clause 8.5 involves an obligation to act honestly in a subjective sense, as this is its natural meaning, and the context does not suggest some other meaning, as it wasn't put to Quinlan in cross-examination that he hadn't acted honestly in this sense. For that reason alone, Macmillan cannot now assert that he did not do so. So going back to my earlier terminology, Lady Justice Arden has held there to have been no breach of the autonomous duty because no case of dishonesty has been put to Mr. Quinlan at trial. That left the question of whether derivative implied terms could assist Mr. McKillen.
But you say that, there was an express term.
Well, I was about to say, so in Yam Seng, that is an issue that is left to implication. But here, unusually, there is an express clause, clause 8.5.4, that in terms mandates fidelity to the spirit of the bargain. And so far as that's concerned, you can see how Lord Goldsmith, for Mr. McKillen on appeal, put his case on that. If you look at bundle page 1848, back at paragraph 48 again, Lady Justice Arden says that leaves 8.5.2, and then she goes on, Lord Goldsmith argues for a meaning for this expression that was really the same as the meaning of 8.5.4, namely that it required the court to enforce the spirit of the agreement and not just its back letter. And you can see he refers the court to CPC in aid of that submission. And then for Lady Justice Arden's treatment of that, you go back over the page 1849, and it is paragraphs 52 and 53, and if I can invite you to read those to yourselves. So the point Lady Justice Arden is making is that even where, unusually, as on the facts of Carroy, you have an express obligation of fidelity to the spirit of the agreement, that obligation only operates at the level of conventional contractual implication. That is the submission that I made to the court this morning.
Sorry, so forgive me for interrupting. Doesn't she say, para 53, interpretation or implication? It's a mirror image of the process.
Yes.
Of interpreting an agreement or implying terms into it. So
yes,
one or the other.
Yes.
That's maybe both.
That's a fair comment.
Okay.
So it may be relevant to the construction of express terms. It may be relevant to the implication of unexpressed terms.
When you say it, do you mean
the obligation.
Contractual obligation. I mean, I slightly wonder whether she is saying that, or rather, it doesn't add anything at all, because we'd be looking at these things anyway for interpretation or implication.
Which is the point, I think, Lady Justice Arden is making in paragraph 53. And Your Lordship made that point to me this morning, and I made the point it comes out even more clearly when you look at Lord Justice Morbeck's concurring decision in a moment. And there is, when you ask yourself, but for my purposes, all that matters is to dispose of the suggestion that the obligation of fidelity to the bargain asks the court to divine what the spirit of the bargain is in some way that is divorced from interpretation, and then to say that is somehow enforced by the obligation of good faith. And to the extent that is what her ladyship is saying, I make the point again, that is on all fours with the reading of Yan Seng, which I suggested to the court this morning. The question then becomes, is her ladyship's analysis of the good faith issue part of the ratio? That requires the court to dive into the separate decisions of Lord Justice Morbeck and Lord Justice Reimer. I will come back to these in more detail if I have to, if it's suggested that Lady Justice Arden is out on a limb on this. But to cut to the chase, in my respectful submission, the position is that both of the other two Lord Justices support her on those points. Lord Justice Morbeck's decision starts at paragraph 132, bundle page 1861. I agree the appeal should be dismissed broadly for the reasons given by Lady Justice Arden, but in relation to some aspects I have reached conclusions which differ from these. And then his discussion of good faith, you see on bundle page 1865, if you look at his paragraph 145. So in the last sentence of that paragraph, Lord Justice Morbeck takes a point which Lady Justice Arden does not, in saying that the breach of an obligation of good faith may not count as unfairly prejudicial conduct for Section 994 purposes. And that's something different to what Lady Justice Arden has said. He doesn't expressly deal with the question of honesty or dishonesty. I've showed you that he opens his decision by saying he agrees with her subject to certain things he goes on to say. And then that second sentence, starting in the third line, in the light of the modern approach to construction exemplified in Belize, I doubt whether in this case either of these clauses has any practical significance, is effectively the point I understood my Lord Justice Newey to be making to me earlier on.
Which point was I making at the time, Mr. Glenhill?
It was does the obligation of fidelity to the bargain matter if what is in play is an implied term?
So I see, I mean, it just on paragraph 145, I slightly wonder whether Lord Justice Morbeck is going further than Lady Justice Arden, because he is saying perhaps not only does 8.5.4 not add anything, but 8.5.2 doesn't either.
Yes. He may be.
I'm not sure the last sentence can be right either, actually. As I recall the case, wasn't the point that if the preemption provisions had been triggered, the company had, under its articles, the ability to step in and enforce them, and that would have been, the failure to do that would have been conduct of the affairs of the company, or at least an omission of the company anyway. which would have fallen under 994.
Yes.
Um,
Be quite clear, I'm not for a moment relying on that last sentence.
no.
Then, so far as Lord Justice Rymer is separately concerned, his decision starts on bundle page 1867 by the first full punch, paragraph 156. I've read in draft the judgments of Lady Justice Arden, Lord Justice Moore-Bick. I agree the appeal should be dismissed, but not in all respects. For the reasons Lady Justice Arden has given, I add the following observations. So, on a fair reading, he is agreeing with her judgment, subject to the points that he goes on to make. I'm going to take this fairly quickly, but you will see that he then structures, Lord Justice Rymer, structures his decision with a number of subheadings: A on 1867, B and C on 1869, D on 1870. It runs down to, I think, his section E on page 1873. All of those 5 sections are directed to the other 3 issues in Lady Justice Arden's list of 4 buckets that I read out to you at the beginning. I'll give you the list for your note. Lord Justice Rymer's sections A through C address what Lady Justice Arden called the practical effect and the proprietary interest arguments. His sections D through E deal with what she termed the security becoming enforceable argument. So Lord Justice Rymer had his own views on those 3 separate points, but he does not dissent from how Lady Justice Arden disposes of the 2 limbs of Lord Goldsmith's arguments about breach of the good faith clauses, with the consequence we say that he adopts her reasoning on.
He obviously had expressed views before on this clause. I'm afraid I don't remember the history of this, but if you go back to Lady Justice Arden at paragraph 54, she's saying, I haven't gone quite as far as Lord Justice Rymer had gone in the previous case.
Yes, your Lordship is right to pick that up. 2 rounds of this litigation in the Court of Appeal. And in the first round, I stand to be corrected if I'm wrong, but I think Lord Justice Rymer takes a fairly restrictive view of the relevance of these good faith provisions. I'm not relying on that for this purpose. All I need from it is the passages that I've shown you in Lady Justice Arden's decision and the concurring decisions.
Yeah.
The 5th of my 6 cases is Mr. Justice Newey's decision in Barnsley and Noble. We put away Carroyne now. I'll take this very quickly indeed, because this is the only one of my cases which isn't in fact my appellate decision finding on the trial judge. It's in Bundle 1, tab 4. We can start it off on page 207. This was concerned with a provision in a trust deed in a will, and it was an exculpation provision saving the trustees in the event of self-dealing. On bundle page 207, you can see the heading 4 lines down from the bottom, self-dealing. Towards the bottom of the page, Mr. Smoohar's primary defence to the claim, Mr. Smoohar was counsel for the defendant, is that the trustee can take advantage of a provision in Michael's will which expressly permits self-dealing in certain circumstances. And you can see that it sets out the provision, it quotes from it at the bottom of bundle page 207. Over at 208, there are certain provisos, and the first one is the one that matters, Roman 1. Every trustee personally interested therein shall have acted in good faith. Towards the foot of that page, paragraph 266, you'll see Mr. Smoohar refers Mr. Justice Newey to Medforth and to Matthew, and then paragraph 267 over the page on bundle page 209. This, I think, is what I showed His Lordship at first instance in my closing submissions. I showed you the transcript earlier on, but the quote wasn't apparent from the transcript. tail end of paragraph 267, 4 lines at the bottom. In my judgment, therefore, a trustee will only fall outside proviso 1 if he's acted dishonestly or otherwise improper motive or conscious impropriety. This requires proof of a subjective state of mind, not an assessment by reference to what objectively the law requires of a trustee. So that was the second of the two authorities on good faith I relied on at trial in closing submissions. And that then takes me to the sixth and final of the cases I was going to show this court, which is in file 2 of the authorities bundle. Forgive me, it's not. There's a supplemental authorities bundle, 2 volumes, and it's in the second volume of the supplemental authorities bundle. And within that, it's tab 75. It's a decision called Sky and Sky King, decided in July of last year. And this was concerned with provisions in the EU and UK trademark legislation. And as with Unipolaris, of course, I unhesitatingly accept that these are comments made against a specific statutory context. And actually, it's a little bit more than that, because it's also an EU-wide instrument that's under consideration. There is a summary of the case law on that point. If you turn on to bundle page 2937, it's the decision of Sir Christopher Floyd, with whom the other 2 members of the panel agree. I'm sorry, I've just appreciated that my Justice Newey was on the panel, so there we go. So you see the summary, of course, at paragraph 67.3 and 4. 3, the concept of bad faith presupposes the existence of a dishonest state of mind. But the main reason for showing you this is a point which will become relevant when we come on to consider the Respondents' letters, which are some comments that Sir Christopher went on to make at bundle page 2941. And he's dealing there with a different decision of Mr. Justice Newey's in a case called Jaguar Land Rover and Bombardier. He summarises it at 74, then at 75 he says Mr. Justice Newey had an alternative basis for rejecting the claim of bad faith. And then you see what that was. If you look at the bottom of 2941, the last 5 lines in the quotation, given the serious nature of an allegation of bad faith and the obligation to plead such an allegation fully and properly, that seems to be by itself a reason for concluding that the defendant has not shown that there's any real prospect of success on the point. And then over the page at 292942, paragraph 78, I agree with Mr. Justice Newey that an allegation of bad faith is akin to an allegation of dishonesty in accordance with conventional principles. The party against whom bad faith is alleged must be told in clear terms the respects in which his conduct is to be so characterised, and the facts on which such an allegation is being made. That completes the discussion of the authorities, and we submit in light of them that there is no question of the trial judge in this case having made a finding of the investors having the requisite state of mind for breach of the duty of good faith in relation to the circumstances concerning Dr. Sachs's removal. He did not make a finding that the investors had been subjectively dishonest in any sense, nor, critically, did he make a finding as to their state of mind and say that even if they did not appreciate that what they had done was dishonest, they should have done so by reference to objective standards. There is no discussion of that at any point in the judgment, whether by reference to Dr. Sachs's removal or anything else, for this sufficient reason, that he thought he did not need to make such findings because he thought it was unnecessary, because he believed that it sufficed to show that the investors had violated the spirit of the bargain and undermined the constitutional settlement by removing Dr. Sachs. that completes what I was proposing to say about finding number 1. And I'm now going to develop that submission by saying what we say the implications are for the judge's reasoning more generally if you accept our analysis thus far. For this purpose, if I may take you back in the core bundle to tab 6, to our summary of findings. Bundle page 82, and you may find it helpful for this section of my submissions to keep this document out, take it out and keep it loose so that you can cross-refer to it. So, looking at this document, I've dealt with point number 1. I'm going to come back separately to finding number 2. I'm now going to deal with findings number 3 and 4, these being the findings that the CPGL directors breached 2 statutory duties as a result of their participation in the events leading to Dr. Sachs's resignation. And to start this off for good order, I should take you quickly to the relevant statutory provisions. I'm sure they'll be very familiar, but it is the appropriate starting point. They're in volume 7 of the authorities bundle, tab 57. Bundle page 2398. So, breach of duty, director's duties in relation to Dr. Sachs's removal. The trial judge found breach of 2 provisions, the first of which is the one you see at 171A. 171, duty to act within powers. Director of a company must, A, act in accordance with the company's constitution. So that is I can put it, a hard-edged question, whether or not there has been an infraction of the constitution or not. That's got nothing to do with state of mind. Then over the tab 58, is the familiar provision, section 172, enjoining directors to promote the success of the company. 1, a director of a company must act in accordance with the way, in good faith, he would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard among other matters to, and then you can see a list A to F, and the only one that the judge believed to be relevant was point F, the need to act fairly as between the members of the company. So section 172 creates...
Did anybody draw his attention to subsection 3?
I can't say for certain as I stand here, but I'm not sure that they did. And my Lord will remember that at one of the case management conferences, you raised the question, and we have to some extent addressed it in our skeleton argument, as to whether or not, because in the case of any argument about the scope of a provision, or if the question is one of implication, one of the key aspects is the statutory background and the statutory obligation which the officers are under. Now, so far as Dr. Sachs's removal as director is concerned, that point, as far as we can see, I may be missing something, Your Lordship may have something specific in mind, but it doesn't bite, because that is a power exercisable by shareholders in general meeting. But to the extent the question is, could Dr. Sachs be removed as an employee? That is a decision which is given by his service contract to the board.
Sorry, we're looking at the question of whether directors breach section 172(1)(f).
Yes.
By participating in the events leading to Dr. Sachs's removal.
Yes.
And I'm not making any other point at the moment beyond the point that if one looks at section 172(1)(f) and says that directors have to act in a way that they consider in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and in particular to act fairly as between members, that is expressly subject to any rule of law which requires directors to consider or act in the interests of creditors as a company. So taking it away a little bit from this case, but not too far. No matter what the shareholders have agreed between them, if the directors of a company think that they must take an act which is necessary to protect the interests of creditors in discharge of their fiduciary duties to the company, the fact that shareholders may, between themselves, have agreed something else is irrelevant.
I understand.
It cannot be that to act fairly as between the members requires them to subjugate the interests of creditors. That's the point. I'm just simply the point I'm making. The hierarchy is quite clear. Where there is a rule of law to this effect, creditors come first, and the duty of the directors to their company is to do what they think will protect the interests of creditors, irrespective of what the shareholders have agreed.
I misunderstood your Lordship's point. I understand it now. If the question is, was it put in that way, I suspect it wasn't put in that way by me at trial.
And I will lead on to the point which I did raise at the CMC on a number of occasions. When we're looking at the content of clause 4.2, at what point do the interests of creditors intervene, if any?
Well, the answer to that question...
And by the interests of creditors, I'll just make it very clear, as I understand it, the assertion was that absent investment, which was predicated upon a change of management, the company would fail.
Yes.
And become insolvent.
Yes.
But my Lord, there was no case brought below at all of any insolvency. No suggestion that the company was at risk of insolvency.
Well, my learned friend is right to the extent that there was no pleading to the effect that there was an impending insolvency, but it was at all times absolutely common ground between the parties that this company was dependent upon continued shareholder support in order to continue in being a tool. The position that was arrived at in March was that absent an $8 million subvention from the then shareholders, it wouldn't be able to meet its payroll.
I was going to ask at the end of today, I personally would welcome some references for that in the judgment.
Certainly.
I mean, just thinking around it for a moment, there was a short-term question and a longer-term question. And as I understand it, a decision was made in time or whatever that there would be short-term funding, so the 8 million or whatever would be paid. Longer term, as I understand it, it was seen or thought that the company would not continue in being unless there were more funding. I suppose it doesn't necessarily follow that it would become insolvent as opposed to just being shut down.
Yes, I mean, I think if the question were technical insolvency, one would have to look at the accounts. Your Lordship will remember from the judgment that this wasn't, in effect, a company in which money had to be put in to enable it to continue to develop. And if the money wasn't put in, it wouldn't continue to develop. It was a company which had very substantial overheads because it owned, as the judgment records, the largest gallium arsenide fabrication plant in Europe, with a running cost from memory in the region of $1 million a month. So the simple position, which was non-revenue generative, as the judge found, even with the benefit of the one contract which it had with a company in Scotland called Sachs. So on any view, it was entirely dependent on continued shareholder support to continue in being.
And just remind me, all the money that was put in by shareholders went in as equity or as debt?
I think there was a small amount that went in as debt in August 2016. Some may have gone in later, but the overwhelming bulk of it went in by way of equity subscription.
Yeah.
So I entirely take the force of my Lord Justice Snowden's point, that in appraising the duty that arises under section 1721, 1713 is highly relevant, and we have put into the authorities bundle the most recent appellate authority dealing with that, this court's decision in Sequana. The point that I was making by reference to 1721, even before we come on to that, is there is a twin aspect to it. There is the substantive duty incumbent upon directors to act in good faith in a particular way, the way that they consider promotes the interests of the company. And then there's a second and separate aspect, what I may call a procedural aspect, to have regard to a list of prescribed matters in subsection 1A through F. Putting the section away, the judge's treatment of this is back in the core bundle, tab 8, bundle page 174. And it starts at paragraph 420, where he says, at the time of Sachs's departure, the Vollin appointed nominees on the board were Fletcher and Berkey. 425, the decision to remove Dr. Sachs was really one taken by the investors, as majority shareholders, not by the directors. And then over the page, you see what he says at 46. Nonetheless, Fletcher and Berkey played a part. At the time, they were directors of CPGL. They were present at the meeting of the Vollin Investment Committee on the Saturday and supported the approach of removing Dr. Sachs, which was then implemented at the meeting on the 14th of March. And then you see the conclusions that he draws out from that at 428, 429. 428 is the breach of the obligation to adhere to the company's constitution, and that follows exclusively from the finding that Dr. Sachs cannot be removed.
And the contractual obligation there is 4.2. There is no other contractual obligation.
No.
Is that really part of the Constitution?
Well, my Lord raised that point earlier on today, and we'll give it some thought overnight and revert tomorrow. But certainly at trial, it was conducted on the basis that the shareholders' agreement, by virtue of section 17, was also part of the Constitution for this purpose, but we will reflect on that. But in any event, there's no question there of any finding of mental state. It's a simple point.
So that the breach of the Constitution would be the breach by whom?
By the investors,
clause
by the
4.2.
shareholders, in having removed Dr. Sachs. And the breach by the directors is said by the judge to be their participation in a meeting at which that is discussed. That's the full extent of it.
Well, and Mr. Fletcher delivered the decision.
Yes.
One wouldn't think the delivery of the decision could be a breach.
No.
I mean, even leaving aside the question of whether or not there was any breach of anything by removing Dr. Sachs, that analysis raises some pretty fundamental questions about why the judge has found a breach of duty by directors in a decision where he says 2 paragraphs earlier on, the decision is taken by the shareholders. You then come on to paragraph 429, which is his finding of breach of section 172. I said a moment ago that there are 2 components of that, the duty to act in good faith and the duty to have regard to the list of prescribed matters.
Sorry, I may be getting confused here, but is state of mind playing any part in the director's duties aspects?
No.
No. So you're addressing us, as I understand it, on what follows if you're... Oh, yes, I see. So this is nothing, we're moving away from dishonesty completely.
Yes, we are.
Now, my fault.
Yes.
Thank you.
And then at 429 is his finding of breach of section 172. And what he is not finding is he is not finding that the directors have acted in bad faith.
And to be clear, what we're concerned with here is the Regent crest, I mean, aside from the bit that obviously Mr. Hollington relies on, 1721F, the primary obligation is to act in the way in which you consider in good faith would be most likely to promote the success of the company. There's no finding of breach of that,
No.
is there?
Absolutely not. The finding is exclusively, if you look in this paragraph,
In supporting the initiative to remove.
Is there any finding, well, Mr. Hollington raises, is there, I'm not aware of any finding that a director thought that he was acting otherwise than in the way that he considered was most likely to promote the success of the company.
absolutely right.
And to the contrary, in relation to the shareholders at least, we've seen that the judge accepts that they were acting in what they thought was the interest of the company.
Precisely so. The sole basis for the finding that you see in paragraph 429, he says, basically in 428 he said Dr. Sachs has been removed and he couldn't be removed, so the Constitution has been breached. Then in 429, I think it must follow that Mr. Fletcher and Berkey were in breach of their duty under 172. I say that because discharge of the section 172 duty required them specifically to have regard to the need to act fairly as between the members of the company. And he says, in supporting the initiative to remove Sachs, Fletcher and Berkey must obviously have disregarded the separate and specific interests of the minorities in having him remain in post for all the reasons already described above, including in particular their interest in maintaining the overall constitutional balance, that phrase again, enshrined in section 2013.
I mean, at most, section 172 requires you to have regard to the need to act fairly.
Yes.
That is a subjective matter, isn't it? Did you subjectively have regard to the interests of different members of the company?
Well, the judge, I need to be a little bit careful because my recollection of the cross-examination that was conducted is necessarily very imperfect 18 months later. But what the judge has done is to deduce from his finding in 428 that they must have failed to have regard to that at all.
But disregarded doesn't necessarily mean not having regard.
Quite.
Sorry.
So they could have, in fact, had regard to it, but just decided to come to a different decision having regard to other considerations.
I mean, that must happen all the time.
Yes. I mean, the mere fact that they've agreed or participated in the events leading to Dr. Sachs going doesn't of itself entail at all that they've disregarded the relevant consideration. And take it a stage forward, even for a moment, accepting forensically that they had, the circumstances that obtained, where is the prejudice? In a case where the investors were saying we're going to pull the plug unless he goes, how is the technical failure to have regard to the matter, which subsection F enjoins them to have regard to, conceivably prejudicial? But the fundamental point is the point that you see in that last line, which is, once again, the basis for the suggestion that there has been a failure to have regard to the prescribed matter is the conclusion that the judge has already arrived at, that the minority shareholders have an interest, quote, in maintaining the overall constitutional balance, meaning in this context, Dr. Sachs's place on the board. So if I'm wrong in saying that there is no hard prohibition on his removal, this point goes to.
But in any event, putting aside anything else, if the directors form the view subjectively in good faith, a la Regent Crest, that there is a that the success of the company for the benefit of its members as a whole requires the removal of Dr. Sachs, it's at the moment difficult to understand how the need to act fairly as between members or to give effect to a shareholders agreement can in any way override the primary requirement, which is to act in the way that they consider as directors, as fiduciaries.
With respect to the judge, he appears to have elevated what the section only prescribes as a relevant consideration into being a determinative point. That's plainly not what the section says.
Is there any case you're aware of where breach of section 1721F alone hasn't gone anywhere?
Has anybody ever actually explained what section 1271F means?
Well, if your lordship's not aware of it, I'm certain.
Well, no, I'm not saying that I would be aware of it, actually. Others may be, but it hasn't featured high on my consciousness, but that's not any guarantee of anything.
There is one case before the statute where it was said that the duties did act.
Well, that's macro Ipswich.
Yes, it may be that.
Which then got written in at Lady Justice Arden's instigation and support, she being the author of that decision, to section 172. But is there anything subsequent to the Act?
Not that I'm aware of yet, but we'll check.
Right.
Going back to my list of findings. So I've dealt with 1, 2, and now 3 and 4. 5 and 6 I'm going to come on to separately. 7 and 8 is Mr. Faulkner's removal. And I can take that extremely quickly, because if you accept the submissions I've made in relation to finding 1 and findings 3 and 4, findings 7 and 8 go with it. And for that purpose, it's probably sufficient in the bundle just to take you within the judgment to page 188. On 188, towards the bottom of the page, you see his heading, Roman 13, removal of Mr. Faulkner. Over the page, and just so you understand the structure, on this page he deals with the breach of contract claim against the investors. The next page he deals with the breach of duty claim against the directors. 504 says in relation to the investors, 2 points arise. The first is essentially the same point already made above regarding the position of Dr. Sachs. 5 lines down, the actions taken by the investors to remove him, Faulkner, from his position as director were on the face of it unfairly prejudicial for just the same reasons as in the case of Dr. Sachs. They were unfair because they involved the investors exercising their voting power to exclude Faulkner in a manner which obviously had the effect of overriding the agreed upon constitutional balance. Those words again. And then over the page for the finding of breach by the directors, paragraph 511. First sentence says it all, same analysis applies as above in relation to the removal of Dr. Sachs. So if 1 goes, 7 and 8 fall. And then looking back at my table, 9 and 10 require a little bit of separate spade work. These concern the appointment of further directors to the CPGL board after Mr. Faulkner was voted off in October 2016. So these last 4 findings, 9, 10, 11 and 12, are all dealing with the post-Faulkner period. And to understand the judgment on this point, we need to look first of all at a couple of provisions we haven't yet looked at. Keep the judgment to hand, but if you can take out the second volume of the core bundle and go to tab 21, and within that bundle page 621, I mentioned this provision in discussion earlier today, but we didn't actually go to it. Article 14.2 at the bottom of bundle page 621, subject to the approval of Faulkner and Sachs, the directors may appoint a person who is willing to be a director either to fill a vacancy or as an additional director. So that's the power of the extant board members to appoint somebody else to join the board, in addition to the power that the shareholders have. And if I can show you how this point was pleaded, because it does help to illuminate the discussion that you'll then see in the judgment. So that's back in the first volume of the core bundle, tab 12, bundle page 258.
Sorry, give me the
258.
Core 258.
Tab 12, page 258.
Yep.
And if you look at 258, we're in the petition, and the case for material purposes was put in two rather different ways. The first way that it was put was at paragraph 78.1. So you'll see there's a long list of the appointments that were made when Mr. Faulkner was taken off the board. Dr. Wu, Mr. Mercer, Mr. Tatianen, and so on. And it says that all of these were made without the consent of Faulkner or Sachs under Article 14.2. So the first way the case is put against us is that even after Dr. Sachs and Mr. Faulkner are off the board, Article 14.2 means that we had to have their consent to appoint these additional directors by board resolution. Just pausing there, that is, if I may put it this way, a pretty formal point, because any of them could have been appointed by shareholder resolution. So it's purely an objection to the fact that the appointment is made by board resolution. And then you see at 78.2, there is a catch-all alternative case made against all of the board members, Fletcher, McDermott, DeCourt, Bolger, and so forth. And it said that by effecting these further appointments, they breached, among other things, their duty of good faith under clause 4.2 and a number of other provisions in the shareholders agreement, which we haven't yet looked at. And two of those provisions were provisions the judge relied on, and I just need to show them to you quickly. So we're going to look at clause 5.2 and 5.3a. And that's at tab 20 of the core bundle. Bundle page 544. And I'm just showing you these because this is the first time we've come across these in the account of the judgment. Bundle page 544, just glance if you would at 5.2 and 5.3a. I'll come back to make some submissions about the scope of 5.2 by reference to the defined term you see there, capital B business, in a moment, but I just show you those so that you understand what the judge is referring to in the passage of the judgment we're now going to go to. And that's back in the first volume of the core bundle, tab 8, page 1. So on that page, you can see by the second hole punch, the heading Appointments of Further Directors, and the relevant section runs on to bundle page 192, paragraph 527. And if you just turn back a page to page 191, you can see, I'm not going to ask you to read it, but between paragraphs 519 and 521, trial judge deals with the first way the case is put in the petition. So what he's dealing with is the suggestion there that because we made these appointments by means of board rather than shareholder resolution, they were improper because we didn't get consents from Dr. Sachs and Mr. Faulkner. And we don't need to go into it in detail, but he doesn't accept that submission. And then at the top of the following page, you see a reference to him saying Mr. Hollington seemed to reply on some implied obligations, but he says that wasn't developed. And then the dispositive part is paras 522 and 523, and if I can ask you to read those to yourself.
Anyway, all constitution based, you say?
It is.
Yep.
There's no suggestion that in effect, and nor could there conceivably have been, that in appointing additional members to the board, either the investors or the director acted for some dishonest or improper purpose. The simple point that he is making is that the constitutional balance has been further undermined by these appointments.
But, sorry, is there there is a point on Article 14.2, which is, have I missed this? The point I thought that's being dealt with is that even after they are removed as or ceased to be directors, that Article 14.2 required their approval to the board appointing new directors.
No, my lord, I don't think that's right. I think that's the point which the judge addresses between 519 to 521. And it's fair to say that the discussion of that point, that's why I showed you the two separate ways in which it was put. And the discussion of that point is pretty inconclusive.
So he doesn't find a breach by reference to
No.
Article 4.14.
So my submission to the trial judge was, after they've left the board, we didn't need their consent. And I also said it was at the very most a purely technical defect because they could have been appointed by shareholder resolution in any event. The judge doesn't sustain that. But what he does sustain is the alternative pleading. And that's what he's doing at 522 through to 523.
Sorry, when you say he doesn't sustain it, means he effectively finds in your favour, albeit not in those precise terms.
Yes. But then at 522 and 523, he accepts the submission that there's either been a breach of the duty of good faith or the two other very general provisions of Clause 5 I showed you a moment ago, because the constitutional balance has been subverted. Second line of 522, another example of the machinery of the 2013 Constitution having entirely collapsed. To the extent, I say this carefully, but not intending this discourteously, to the extent we understand that, the point the judge appears to be making is that if these appointments were to be made and made by a board, they had to be made by a board with Dr. Sachs and Mr. Faulkner on it. Had that been the case, given the operation of Article 14.2, they would have had a veto. What he appears to be saying is that because they have been removed, the protection they would have had under Article 14.2 has gone. And so this is another instance of the breakdown in the constitutional settlement that results from their expulsion. So again, we say if we're right on our fundamental submission about the constitutional settlement, finding 9 goes, and precisely the same follows in relation to the follow-on finding at paragraph 524, which is the mirroring finding of breach of director's duties 171A and 172. And the judge doesn't there clearly articulate it, but again, we think that by that he must have been referring, to the extent he's relying on 172, to 172(1)(f), in other words, a failure to have regard to the interests of the minority shareholders.
And just going back to 523,
Yes.
I can quite see that what you said already about clause 4.2 covers what you would want to say here. But we've got 5.2 and 5.3a. So the judge has found that what was done meant that the business was not being conducted in accordance with good business practice and on sound commercial and profit-making principles, and found that the business isn't being conducted in a proper and efficient manner and for the benefit of the companies. Any more to say about that?
Well, there's no separate discussion or analysis of those provisions in this judgment at all. And I will come back separately in a moment to what 5.2 is doing. And again, to flag where I'm going, clause 5.2 is concerned with the proper and efficient conduct of the capital B business. And I'll show the court in a moment how the term business is defined. What it's concerned with is the company conducting the business of making projectors and analogous technology. This has got nothing to do with these sort of questions in relation to management, board appointments and so forth.
It's clear the judge placed no significant weight on this, but what do you say about 526 and 527? Breach by taking the number of directors over 7.
Well, the submission, we accepted that there had been a technical infringement for a period of a few months of the maximum limit prescribed by the shareholders agreement of 6 on the number of the board. And the submission that we made to the judge was that we accepted that there had been that technical breach, but that it was on no possible view prejudicial. And your ladyship bears in mind there are 2 components in the test that the section posits. It has to be unfair and it has to be prejudicial. And
Yep.
we said on no conceivable view was it.
Thank you.
I was just looking at the agreed table of directorships. So we've gone past the stage where Dr. Sachs and Mr. Faulkner have departed from the board.
Yes.
And at that stage, I see that you were left with Mr. Fletcher, Mr. de Court, and Miss McDermott as the 3 directors.
Yes.
And so what we're dealing with here, or concerned with here, is the appointment of additional directors beyond those 3 who had already been appointed by the investors.
Yes. So we went from, I mean, if I could put it this way, 100% board control on a board of 3 to 100% control on a board of 6. And very briefly, as my lady points out, a board of 7 by mistake for a short period of time.
So the thesis is that in adding additional people to people who were already appointed by the investors, you have led to a result where the business isn't being conducted with good business practice and in a proper and efficient manner.
Yes.
Which isn't absolutely obvious,
No.
but even if it were right of itself, as you say, it doesn't look very prejudicial.
No. I mean, in our skeleton argument, we used the, I hope not discourteous expression, this reliance by His Lordship on those 2 other sweep-up provisions in Clause 5 are simply different legal wrappers for the same underlying conclusion.
Yes.
I mean, there's no separate analysis of those 2 provisions anywhere in the judgment. There are no separate facts found that would support a breach of those 2 provisions separately. If I can put it this way, he's hanging the same coat on 3 different hooks.
But in any event, you were going to make a point about business, capital B,
Yes.
in 5.2. I mean, the business that has to be conducted in accordance with good business practice and sound commercial and profit-making principles is the business of supply of projection products.
Absolutely right. It may be helpful, I've referred to it, so it may be helpful to take all members of the court to it. So back in file 2 at tab 20, the relevant definition
Yeah.
is at bundle page 'Sorry, I'm in the wrong agreement.
537.
That's the 2010 agreement. It's the 2013 agreement in tab 20,
Page 537.
and it's 537. Yeah, thank you. The production and supply of projection products and technologies and all activities reasonably ancillary and necessary. I mean, in our submission, neither of these 2 provisions in clause 5 have simply anything to do with this at all.
Well, that's 5.2.
Yes,
5.3a is wider because it doesn't talk about business with a capital B.
yes,
It talks about business with a small b and affairs.
yes.
Affairs must mean,
Can mean internal governance.
as
I'd
opposed to
accept that.
business capital B meaning producing projectors.
Yeah. But there is no finding anywhere by the judge that additional board appointments infringe that provision if his finding that there was no infringement of clause 4.2 falls away. There's simply no separate consideration of it.
As to whether it was not, as to whether it was inefficient or improper to have 7 rather than 6 directors, for example.
Or 6 rather than 3. I mean, the 7 is a slightly different point because that's the breach of a hard limit. But if one leaves that technical infringement aside, the real question is that provision breached by having 4 directors rather than 3 or 5 rather than 3 or 6?
When, I mean, there may have been evidence before the judge as to why these particular people were chosen, but one imagines they were chosen for a reason because they were thought to bring something to the board.
And is the hard limit though? Is the hard limit in the shareholders agreement?
Yes, it is.
And so the question of whether that is a breach of section 171A by the directors depends upon whether that's part of the constitution of the company.
It's clause 7.1 on a bundle page 546. Subject to clause 7.3, the maximum number of directors holding office at any one time shall be 6.
That's in the shareholders agreement.
Yes, bundle page 546.
Right. If that's not part of the constitution of the company,
then it goes.
then that's not then infringing that is not a breach of section 171A because the articles contain a similar limit.
I don't believe they do. I'm sure Mr. Hollington will tell me if I'm wrong, but I don't believe they do. I think that limit is in the shareholders agreement only.
The breach of Article 14.2, as I understand it, is not the number, but the lack of consent from Dr. Sachs and
Yes.
Mr. Faulkner.
Yes. But that's the point the judge doesn't uphold.
Right.
So that deals with findings 9 and 10 in my table, and I'm now dealing finally with findings 11 and 12. These concern the sale of a factory at Newton Aycliffe.
Now we have reached 4:15. Can we just take stock for a moment?
Yes.
Did your I haven't looked actually. Did your timetable stop at 4:15? It did go to 4:30, did it?
It went on until 4:30, and I should candidly accept your lordship. I'm 75% of where I'd hoped I was going to get to today.
So you wouldn't wish us to sacrifice a quarter of an hour? Maybe just check that doesn't cause inconvenience. No. Okay.
And perhaps I can have a discussion with your lordship at the end of the day about where that's going to get us to. So I'm on findings 11 and 12 now. This was the sale of the factory at Newton Aycliffe. And as you will have seen from your pre-reading, there was originally an allegation that this facility had been disposed of at a gross undervalue to a party connected to Vollin. And that allegation failed comprehensively on the facts at trial. The judge nevertheless went on to hold that the circumstances surrounding the sale disclosed breaches of duty, once again because he thought they disclosed breaches of the 2013 constitutional settlement as he found it to be. And back in the judgment, the relevant portion in respect of this is paragraph 199. We need to start it at 568, which is his conclusion on the factual allegation of undervalue, where he says, in summary, I don't consider Newton Aycliffe to have been sold to Khayyam for an undervalue. Then 569, it follows that the particular potency of the petitioner's complaints is rather lost. Nevertheless, I'm bound to conclude, for all the reasons already given explained above, that the circumstances leading down to the sale involve continuing breaches of the shareholders' agreement by the investors. As before, I identify clause 4.2, good faith, 5.2, 5.3, we've just looked at those. That is because the relevant decisions were not taken by a board of CPGL constituted in the manner required by the 2013 shareholders agreement and operating in the manner contemplated by the 2013 SHA. So once again, the suggestion is that there has been an infringement of the Constitution as he has found it to be, being a board with Dr. Sachs and Mr. Faulkner on it. And then over the page, finding 12, paragraph 200. Forgive me. Bundle page 200, paragraph 575. Sorry, something's gone wrong with my reference.
578 is the finding.
I'm sorry, yes, it's 578. 577, 578. Sorry, 578.
578 is my Lord Justice Newey's point.
Yes.
Yeah.
So a breach of the Constitution. Again, a hard-edged question, not dependent upon any question of mental state. Simply saying that there is a Constitution and it's been ignored.
So even so far as, say, the breach of the Constitution is said to be breach of clause 4.2, and you say, well, that does have a mental element in it.
Yes.
Yep.
Yeah.
Well, so we know if it's breach of the duty of fidelity to the bargain, that's your derivative duty, and you say dishonesty isn't relevant to that.
That's correct. So that deals with the 12 findings of breach of duty in our appendix. And the court will remember that when I started my submissions earlier today, I indicated that there was now left only one point from the CMC's Lord Justice Snowden conducted, where it was suggested that the judge had made a finding of breach which we had not subjected to appeal. I'm going to take that very quickly, given time constraints, if I may. We have set out our case on that in paragraph 42 of our skeleton argument, tab 3 of the core bundle, page 52. In a nutshell, what the judge said was that had there been certain board meetings, there would have been a failure to give relevant disclosure, that there were no such board meetings, and that as a result, the point went nowhere. But I will leave you, if I may, to take the references to that from our skeleton, paragraph 42. And that takes me on to the next topic that I'm dealing with, which is the propriety of the means by which Dr. Sachs was removed. And this, I accept, is the one finding that the judge made which did not turn on the conclusions about what he termed the constitutional settlement. Now, the judge's findings on that you can get from the judgment at tab 8, starting at bundle page 170. And it's the passage running from paragraph 405 on bundle page 170, and it continues all the way down to to paragraph 419 on bundle page 173. But focusing for the moment on paragraph 405, his lordship said, I'd go further and say that the process by which Dr. Sachs's removal was achieved involved a breach of the duty of good faith. In my judgment, there was a failure to deal fairly and openly with Dr. Sachs, and a failure by the investors to take into account the interests of the minorities as well as their own interests. The effect as a result, which even had it been otherwise justifiable, was achieved in a procedurally non-compliant way. And you can see that the judge is addressing that in the first sentence of paragraph 405 as another aspect of the clause 4.2, duty of good faith. And the remainder of that paragraph is strikingly similar, closely similar to a passage in Judge Klein's decision in Unwin, which Mr. Justice Johnson quoted with approval earlier in his judgment. And you see that if you turn back to bundle page 159. And I showed you this, in fact, earlier on. On bundle page 159, there's that quotation from His Honour Judge Klein in paragraph 367. And Mr. Justice Johnson's formulation that you've just read is effectively a quote of what you see in those last two paragraphs, 4 and 5. When acting, they must deal fairly and openly with the claimant. They must consider and take into account their own interests, but also have regard to the claimant's interests. And then we've already seen what he said over the page at 368 and 369. Now, in our skeleton argument, we made the point that Judge Klein's analysis of this process aspect of the duty of good faith borrows heavily from 3 pre-2013 decisions. And in date order, they are a case of Mr. Justice Newberger called Mullins, dated 2003, a case of the New South Wales Court of Appeal called Macquarie in 2010, and a decision of Mr. Justice Sales in 2011 called Barthélemy. And I'll deal with those in a moment, but it's helpful, if I may, to start by just showing you one short passage in Yam Seng, which I suggest contains a short passage which succinctly identifies the principle actually at work here. So if we go back into volume 7 of the authorities bundle where you have Yam Seng, tab 56, and if we go on to page 2375, you'll recall that on that page I invited you to read 137 through 140, but we stopped short of paragraph 141, and if I can start by just asking you to read 141 and continuing over the page, just 141. In our skeleton argument, we submitted that if you look carefully at the complicated facts of both Macquarie and Barthélemy, the principle at work in those cases is no more than what Mr. Justice Leggett is saying here. If A leads B to believe that things are going to work in a certain way, good faith means that if circumstances later change, A may well have a duty to speak out. He can't permit B to continue to labour under a misconception which he has fostered if circumstances change. But we suggest that that is all that those cases decide, and that they do not warrant the conclusion which Judge Klein derived from them, that a duty of good faith creates some general duty of fair and open dealing, or a duty somehow to have regard to the interests of one's counterparty more generally. And we suggest that is particularly so, whereas here the parties have expressly agreed in clause 23 of the shareholders agreement that they do not owe fiduciary obligations to each other. They are each free to act in their own interests. And we derive support for that analysis from a decision of Mr. Justice Coulson when he was still sitting at the first instance. And again, given time constraints, I'll just show you the critical passage that I rely on. If you put away Yam Seng, volume 7, and now go back into the supplemental authorities Bible, volume 2. You have there a decision called Coste. And in a nutshell, this was a construction case in which the defendant argued that the dispute between the parties was within the scope of an arbitration clause.
Sorry, a volume.
I'm so sorry. Supplemental Authorities Bundle, Volume 2.
Yes, thank you. Yes.
And within that, it's tab 67.
I think it must be supplementary volume 1.
Yeah.
In fact, if it's 67, it's
I'm so sorry, you may have different. Yes, right. But it's tab 67.
Supplementary 1.
Yeah.
This was a construction dispute, and the defendant argued that the dispute was referable to arbitration and that the claimant was out of time to make a reference. And there was a good faith provision in the contract between the parties. I can show you that quickly. bundle page 2776. If you look at the first hole punch, the employer and the supplier shall act as stated in this contract and in the spirit of mutual trust and cooperation. Forgive me, it's not quite. The judge goes on to discuss it by reference to the duty of good faith. And the claimant's point was that the defendant had breached the clause because it had lulled it, the claimant, into a false sense of security, which had meant that it hadn't started the arbitral reference in time. Claimed effectively that it had been tricked into not starting an arbitration, and then the defendant said, well, you're now time barred. I don't need to show you anything about the facts, but if you turn on to page 2807, you can see that there's a discussion by Mr. Justice Coulson of the point at 119, going on down to paragraph 124 over the page. I'll just start at 119. I turn to whether or not clause 10, the mutual trust provision, makes any difference. And then he says at 120, in Keating, a parallel is drawn between mutual trust and obligations of good faith. The authorities dealing with good faith are mainly from outside the UK. We then cite some Australian cases, which do, as you can see, reading over the page, put the matter in a fairly wide way. Over on bundle page 2808, you can see it fall. There's a reference to the duty being to have regard to the legitimate interests of both parties in the enjoyment of the fruits of the contract. And then at 122, you can see that he refers to two decisions, F&C, Barthélemy, that's Mr. Justice Sales, and Macquarie. I'm coming on to that.
Can you read 1, 2, 3?
And then at 123, he says, reading above, he says, it is a form of contractual duty which requires the obligor to have regard to the interests of the obligee, while also being entitled to have regard to its own self-interest when acting. I respectfully agree with that summary. I agree too with the passage in Keating about not improperly exploiting the other party, although I'm a little uneasy about a more general obligation to act fairly. And then at 124, you have what we suggest is the key passage, and if I can invite you to read that yourselves. So we suggest that is consonant with the passage I showed you in Yam saying a moment ago. If you've led your counterparty to believe that the state of affairs is A, and something changes, good faith may oblige you to correct the misapprehension that you yourself have fostered. So when one talks about legitimate interests in this context, that is the content of it. It is not some more generalized process duty than that. I was going to, at that point, turn to another authority, which is Macquarie, and I note the time.
Yes. So can we just take stock? As
Yes.
I think you were going to anyway.
So I am, I'm afraid, again, 3/4 of where I had to be by this point.
So in terms of what you have yet to cover, you're dealing at the moment with the judge's findings in relation to the procedure.
Yes,
Then you've got corporate governance.
yes. And then after that, Mr. Hollington's submission that the investors did in fact act dishonestly in the respondent's notice. It may just help if I just indicate what I'm going to deal with in
Yes.
relation to those last two aspects. So the next section dealing with the period between Dr. Sachs's departure and Mr. Faulkner's removal, that's obviously called to my appeal. The other two are in a sense responsive points, but there are 2 points that it seems to me I need to make in opening submissions rather than in reply, subject to any comments that your lordships have. The first is in relation to the suggestion that the judge did find dishonesty or something like it. My learned friend places significant weight on various things that the judge said in July on the permission to appeal application. And it seemed appropriate to me, this was a question which my Lord Justice Snowden raised at one of the CMCs, and it seemed appropriate to me to make some submissions on the principle of the extent to which those are admissible or not. But if the court is saying that that is something that I can leave for reply submissions, then I certainly will. Then in relation to the respondent's notice, as Lord Justice Snowden will remember, we have an outstanding application to strike out what is effectively, we say, the only live aspect of that, which is the suggestion that this court should determine de novo adverse influences. Now, again, I'm very much in the court's hands. If it would be appropriate for me to deal with that in reply, I can try to deal with it that way.
It's actually, the timetable doesn't give you that long to reply. I don't know whether we need to go outside. I'm wondering whether there might be a case for starting at 10:15 both tomorrow and Friday, so that both you and Mr. Hollington get the extra quarter of an hour. But if that causes inconvenience to anybody, then, or if, should we go outside and have a word?
Why not?
Yeah. Right.
Yes. Yes. I was right. Yes. This was the second day about one, wasn't it? Always said he was concrete.
What's that? That's something different. These? No, these. What's that?
You think you're making a gesture.
Yeah,
Won't do it.
All rise.
Where we've got to, Mr. Gledhill, Mr. Hollington, is that with a bit of luck we'll be able to start at 10:15 tomorrow, and if we do, then we'll start at 10:15 on Friday as well, assuming Mr. Hollington would wish to have the extra time. But we can't be sure that that's going to be possible. So what we think is appropriate is to say that tomorrow it will be not before 10:15. With a bit of luck, it will be 10:15, but it may not be. Anything else for tonight? In which case, not before 10:15 tomorrow.
Court rise.